I welcome everybody back to our final panel on finding identities and freeing voices. And I'm pleased to introduce Mr. Kamal Patterson to close the day out for us. Kamal Patterson is Senior Program Officer for the Cultural Antiquities Task Force in the Cultural Heritage Center at the U.S. State Department. And I must also acknowledge the great honor that Congressman Hank Johnson, representing Georgia's 4th District, does us today by joining this panel to talk to us about legislation he is reintroducing, the RAP Act, and that would prevent artists' lyrics from being used against them in criminal trials. It's a piece of legislation I've followed, I've taught with my students, and I am super excited about. So I'm really honored that he has agreed to come and speak with us on this panel. This is not to single out the congressman above other panelists who I'm also really very honored and pleased to have join us, some of whom are my close friends and colleagues, and really, really happy to have you here. But I don't want to steal Kamal's thunder from introducing you. So I will turn it over to Mr. Patterson to introduce them and their scholarship to you. I will just thank you for being with us. And thank you, Kamal, for all of your work in organizing the panel, putting together the thoughts here, the thought leaders, and turn it over to you. Thank you.
Thank you, Director A-Stars, and I'd like to thank the organizers of this amazing conference, as well as the distinguished panelists that I have the privilege of serving as a moderator for in this discussion. Again, my name is Kamal Patterson. I'll be the moderator for this panel, and I'd like to briefly introduce the very august panelists that we have this morning. We have the Honorable Hank Johnson, the U.S. Representative for Georgia's 4th Congressional District, ranking member of the Judiciary Subcommittee on Courts, Intellectual Property, and the Internet. We have 3 pioneering scholars and professors of law, Latif Ntima of the Howard University School of Law, and the founder and director of the Institute for Intellectual Property and Social Justice, Professor Funmi Arewa of the Temple University School of Law, a classically trained vocalist and anthropologist who's also worked in venture capital, and Professor Colleen Chen of Santa Clara University School of Law, who's a highly regarded expert on patent law and its social implications. Finally, we have Nevada attorney, Mr. Caleb Green, a recognized thought leader on intellectual property and society who is deeply engaged in emerging civic issues and supports Nevada's legal communities and organizations. Now, this panel is about finding identities and freeing voices, and this group is perfect to inquire about how we should conceive of this. Now, I want to preface this discussion with the knowledge that IP law alone, is insufficient to protect the control and distribution of works. There are segments of society who attempt to circumvent the sharing of works that they don't like by ignoring or diluting the First Amendment protections that are due to artists. We have seen a movement to have offending works labeled as criminal contraband and mere possession, let alone authorship, seen as eligible to be criminally prosecuted. Remembering, restoring, and renewing our commitment to First Amendment principles outside of IP legislation may be the best route to prevent a purging of works and a resulting loss of valuable IP. The losses which would be felt most deeply by marginalized creators and IP rights holders, such as minority-owned independent book publishers and record labels. Professor Arewa's scholarship has addressed questions of ownership and entitlement to use cultural material, particularly music. Marginalized groups often must ask for permission to use cultural materials that have been recorded or even re-recorded by artists outside the community. For example, African-American artists having to seek a license to use a recording of a folk song that had never previously been recorded. Artists from this community may acknowledge that attribution may not be possible to an absolute degree, but they know from living within the community that there's a narrow list of possible true authors of a work. It's important to recognize that while copyright law requires a license to sample, we also must recognize how elements of African-American musical recordings were lifted and copied by white artists without attribution. And when challenged, white record companies could rely on the Copyright Act to claim that these elements, such as call and response chants, weren't protected because the Copyright Act at that time required such elements to be notated on sheet music. Professor Robert Bronice, who was not a part of this panel, and Professor Arway have examined the harms caused by this abuse of Copyright Act formalities to copy the commercially profitable core of profitable African-American recordings. Such acts stifled or substituted the voice of Black artists in favor of others. Professor Ray discusses the bias that exists toward African-American claims of ownership of cultural elements in music. She notes that there's societal bias that says that these elements are not even worthy of being claimed as property. Yet this attitude creates an entitlement to mine or even plunder these elements, leaving African-American creators with little recourse for redress and harmed by their vulnerability. Professor Ntima and the Institute for Intellectual Property and Social Justice want to mitigate the harm from this plunder and help marginalized creators combat it. They submitted an amicus brief in the recent Warhol v. Goldsmith case. In their brief, they proposed modernizing the fair use factors to recognize authorship and originality of works by marginalized creators and groups more adequately. This approach may limit the misappropriation of their works based on claims of transformativeness. Professor Ntima has also interrogated the very idea of ownership by exploring the creation of identity, and most recently in a book chapter co-authored with fellow Howard Law professor Stephen Jamar. Now, individual identity necessary to prove authorship might be obscured within a community or a larger affinity group. What one artist records using cultural material may have been nurtured from traditions, customs, and lore that has various authors. And functionally, communally acknowledged cultural material means that the work has no authors in our current American copyright system. Our idea of copyright authorship is changing through technology, especially with the advent of generative AI. This technology presents unique challenges to our ideas of authorship and cultural expression. It presents obstacles to the idea of group ownership or individual ownership sanctioned by cultural custodians. Now the lifting of chants, phrases, figure of speech that an affinity group may claim as cultural material can be absorbed by an AI, and then that AI produce a novel work recognizable to the mainstream. At this stage, humans still control how these artificial intelligent entities function, and they can input copyrighted works to an AI alongside elements not being copyright protectable, like short words, phrases, and dance steps not qualifying as a work of choreography. The output of this artificial intelligence may nonetheless be controversial and offensive to communities. For example, FN Mecca, the first AI rapper, went online last year. And one of the creators of this AI was a person of color. Yet the lyrics and mannerisms of FN Mecca were considered offensive to the African-American community with use of slurs and objectionable lyrics. It was quickly shut down or canceled as it may be used in common parlance now. Nevertheless, the technical achievement of creating FN Mecca was laudable, especially with one of its creators being of color. People of color have long gone unattributed for their inventions. Professor Chin will address the credit and attribution gap for minorities, along with the inequities in patent prosperity for minorities. She makes a strong case for diversity and innovation supported by law and ethics. One could imagine an even more diverse creator group for an AI music product like FN Mecca would not have suffered from the same ethical problems. And there's certainly potential to be profitable in a tolerant and conscientious music market. Professor Chen warns of the risk of under-commercialization of ideas from diverse innovators, and Professor Ntima is a strong supporter of the 2022 Unleashing American Innovators Act and has consulted on its drafting. Now, if an AI's creator bears some responsibility for the output of his creation, so too do stakeholders need to shoulder the responsibility of investing more in diversity and realizing the net positive effect that investment in creators, particularly those of color, has on IP creation. The concept of individual responsibility versus collective responsibility in investment in diversity and IP can cut another way. For example, record labels have been criticized for only investing in artists with popular appeal. But the popular appeal of most of their works is because of content that so many consumers may consider problematic. but who is responsible for initiating or fueling these trends of objectionable or problematic material. And what happens when a community or an affinity group, even within a neighborhood or community, claims ownership of these the problematic content? Should problematic content associated with the community warrant a law enforcement response, especially if there is an uptick in violence or unrest in a particular community? And are individuals of artists' violent words or objectionable words protected speech, no matter how others may feel about it? And when do mere words become a true threat unprotected by the First Amendment? These are questions that Representative Johnson, his legislative director, Antoine Monarch, and others in his office asked when developing the case studies that led to the drafting of the RAP Act. Now, the RAP Act is not a copyright law. However, it might be necessary to protect expression, especially when societal attitudes toward expression in the form of rap lyrics have been used to justify prosecution. What would ordinarily just be IP becomes evidence. In fact, a recently established database shows that rap lyrics have been used as evidence in over 700 cases. There may be others out there. If lyrics in the form of rap lyrics are free speech, then society's silence on attacks on lyrics creates conditions for abuse of artists by opportunists in our society. Attorney Caleb Green has worked on issues of preventing the weaponization of copyrighted material against vulnerable communities. Communities in which they bravely seek to document injustice by sharing videos of police interactions. But in California and other places, officers have started playing copyrighted music once they become aware that they're being recorded by citizens. And that's so they can trigger anti-infringement algorithms on video sharing services such as YouTube. And citizens ask these vital questions. Is the individual officer trying to suppress the public voice? Or is it a precinct policy attempting to limit speech to protect due process of officers? Caleb will present solutions to stop IP from being abused, to free the voice of the public to critique police interactions. He will discuss his work on a bill in Nevada that prevents the abuse of copyright used to that chills the uploading of police-involved videos. And Representative Johnson and other panelists will discuss the climate of censorship that is ratcheting up, of which interfering with the uploading of police videos is just the tip of the iceberg. They will discuss its chilling effect on artists. From muralists to musicians, artists to authors, people are feeling that the mere expression of the display of their work could invite government scrutiny that can make them persona non grata in the public square, and that effectively disembodies them not only as artists, but as copyright holders, afraid to claim and control their now controversial works from detractors. Under the threat of criminal fine or prosecution, many artists are worried about being deprived of their liberty even more than their livelihoods. And concerningly, Representative Johnson and his office found that artists of color are the primary targets of government attacks on artistic expression. The limitations of IP law in protecting works and preserving copyright become apparent in the face of forces adamant about limiting, even criminalizing expression. All panelists will address how these conditions arrest the creation of IP and affect the issues of authorship and ownership. And we will begin our discussion with Professor Arewa. Professor Arewa, if you would.
Thank you, Kamal, for that wonderful introduction. Please let me know if you can't hear me. So I want to start out by saying it's such a pleasure to be here. I want to thank everyone. I want to thank the organizers. I want to thank my fellow panelists. I want to talk about, I'm going to try to position my remarks on the economic and business side a bit. I know this panel is going to cover different aspects. I want to talk about the economic and business implications of marginality, particularly in the context of recorded music. So I think innovation and creativity, sometimes as IP scholars, I'm also a scholar of business, so sometimes as IP scholars, we tend to take the business context for granted. And I think it's really important that we talk about that business context because it often involves, we have to understand business models, we have to understand contractual arrangements, and we also have to understand that people often use IP strategically. And those strategies, be it, we see it in patent, we see it in copyright, sometimes we call people trolls, but there are various kinds of strategic interactions that impact how IP actually plays out in real world context. So I think I also write about technology, and I want to say, contrary, often technology optimists have a story or a view that technology will make things better. That hasn't necessarily been the case in music. We see in streaming some of the same issues people have been talking about for at least 2 generations in music have become even more acute during the era of streaming. And we now have generative AI. I don't know how many people heard the Drake and Weeknd song that was released, but that was soon removed because, and it sounded, I didn't know it was, when I heard it, if I hadn't known already, I wouldn't have known it was generated by AI. So as I discuss in my forthcoming book, Curating Black Music, Ownership and Commodification, I want to talk about 2 or 3 different things related to business context. Now, I'm only going to have time to probably talk about 1 or 2, and I'm hoping to reserve the rest for our Q&A period. I want to talk about how we see a recurrent pattern, certainly in music, where people call out the music industry with respect to marginalized creators, particularly African-American creators. The music industry quickly forgives outstanding debt balances. And then we have the same conversation 10 or 15 years later. And this has happened over and over again. And I think in our prior panel, someone talked about how the contemporary music industry to a significant degree has been built sort of on the backs of a lot of African-American artists. And that really highlighted for me, they called Atlantic Records during the R&B era, they called Atlantic Records the house that Ruth Brown built. And Ruth Brown didn't actually get much back from the recording industry, even though the Atlantic Records success was really based on her success as an artist. And she actually was cleaning houses at a later time period and realized a lot of her music was being played on the radio. And she said, why aren't I being compensated? She went to Atlantic Records and they said, well, you actually owe us $25,000. So don't come talk to us about what we owe you. And so she actually managed to find an ally, an M&A lawyer, actually, Howard Beagle, who loved her, who was a big R&B fan. And one of the things I found out is that there wasn't proper crediting of royalties for decades to many of these artists, and they were being assessed costs, which they weren't really due, which should not have been assessed to them. So I want to talk a bit about the exploitative and extractive business models that are pervasive in the recording industry. It doesn't just impact African-American artists, but I think there's a double marginalization that causes it to impact African-American artists to a greater extent than other artists, than at least some other artists. I also, and hopefully in the Q&A, will talk about racial context categories in Black music, which came up in our earlier panel. And I think that's an important thing to think about because my entire book is about the creation of the Black music as category. So I want to talk about, as the discussion on the earlier panel suggests, it's important that our discussion encompass values and norms beyond those related to music in a narrow business sense. So that might include civil rights issues. It also includes issues related to cultural expression and who actually owns cultural expression or who can claim ownership rights. Because as I think was discussed earlier, we've had a phenomenon where a lot of collectors they might be recording scouts, early folklorists, went out and collected what they considered to be Black music. And we see a combination of exclusion and categorization at the same time, because many African-American artists played a broad range of music, from classical to country music, but they were actually placed in categories that were called Black categories. R&B, if you think about R&B as a category, is a mix of a lot of different kinds of music that's unified by the fact that it's music that came out of African-American communities. Those categories were then used to extract and engage in various forms of racial exploitation. And that means, I think, when we talk about copyright, as I talk about in my book, we talk a lot about copyright and incentives to create. We also need to talk about copyright and incentives to exploit, particularly certain forms of racial exploitation, which have been pervasive. And that's not to say we don't have successful artists. We have the notable success of artists like Rihanna, Jay-Z, who were mentioned in the prior panel. But that shouldn't obscure the fact that the music industry was built on the deprivation of ownership rights in ways that continues to impact everyday artists today. Not every artist is as successful as Jay-Z and Rihanna. A lot of my work focuses on how do recording companies in particular actually account for what's owed to artists. And we see systematic manipulation of accounting numbers in the music industry such that many artists don't actually get paid. And that really impacts the everyday artist, for whom the difference between deprivation of royalties can mean the difference between a life of deprivation and a life living with some degree of comfort. And it's those artists that I think we need to think about as well. Just the fact that we have many, many successful African-American artists today doesn't obscure the fact that the fundamental business model is built on an exploited model that goes back to the 1920s. And as I talk about in a joint article I wrote with Matt Stahl that's coming out later this year, is more akin to sharecropping than it is to a kind of business practice that I think we should aim to have. And that brings me, I have a few more seconds. So I want to say, Professor Vatz and Professor Mulrain highlighted the importance of financial and business education for artists in terms of understanding their contractual arrangements, understanding strategic uses of IP. We should all anticipate how people are going to use IP strategically as we advise people, especially people who don't have a lot of resources. Because often the recourse is, well, someone can always sue, but for the average artist, a lawsuit is really not an option because it's very expensive. Even some of the contractual rights that artists have, like audits, aren't really exercised because audits are extremely expensive. So unless you're on a certain level of success, even if you know you're being deprived of royalties, you actually may have little or no legal recourse, either contractually or through litigation, to really get paid. So I think we need to pay close attention to the role of various gatekeepers, particularly when we're dealing with culture of marginalized people, because many of these gatekeepers actually can determine what is called Black music. The category of Black music wasn't necessarily defined by African-American people, but rather by various kinds of collectors over time who decided what should fall into the category of Black music. It's problematic because African-American artists were excluded from other categories like classical music and country. I don't have more time to talk about it. So I think we need to think of, so I'll end by saying that we need to think, as mentioned by all of the panelists on our earlier panel, we need to recognize that creativity is about more than numbers and cost and benefits. But we also need to understand those numbers and systematic patterns in those numbers that deprive artists. And I think that brings me, we need to think about two things. That we need to talk about representation of diversity and representation within the industry. And also we need to think about new business models, because changing representation and increased diversity on a business model that's built on extraction won't necessarily lead to the kind of change that we might want. And one of the things I talk about in that article I called sharecropping, prospecting sharecropping in the record business, is that we need to look more at equity models, because artists should own their rights to a greater extent. And that means more equity rather than the debt model that's the norm. Although we're seeing, as Professor Mulrain mentioned, we're seeing some shifting. So I'm going to end there because I'm over time, but I look forward to our Q&A. Thank you.
Right. And thank you, Professor Rayla. And next we will have Professor Ntima.
Okay, well, thank you very much. I hope everyone can hear me clearly. And thanks once again to Sandra and Sean and Christina and Mary and everyone who has worked so hard to put this wonderful, I mean, this is an incredible conference put together. I've been enjoying the commentaries from yesterday into today, and it's extraordinary how everything fits together and gives us this overview of the IP topography and some of the challenges that we face in sort of addressing some of the issues and problems that we've been talking about. So one of the things that I've been asked to talk about is sort of some of the fundamental challenges that we have in terms of how do we reconcile these dichotomies between minority intellectual accomplishment, marginalized community intellectual accomplishment, indigenous peoples intellectual accomplishment, non-Western intellectual accomplishment, and the Western prevailing IP system. What we've been talking about yesterday and again this morning, we've been getting our arms around the fact that this is a dual problem, right? So we've just been focusing a bit on problems in terms of IP industries, right? And business practices that are exploitative and inequitable and just continue certain problems that we have in terms of race and class and gender. But before you even get into the industries and in the system, we have a prerequisite problem, and that is what was also being talked about in the earlier panel as to, well, who gets to decide what is IP in the first place, right? I mean, because even if you have IP, we've just been talking about how you can still be exploited, artists not receiving their due, not receiving credit, et cetera, et cetera. But we have a preliminary problem in terms of the fact that there are creative and innovative accomplishments in various communities, various societies, And the prevailing Western model says, well, that stuff doesn't count anyway. And several years ago, I wrote a piece, I can't remember the full title, I just remember the portion that had to do with what's mine is mine, but what's yours is ours, right? And so you have these systems, these Western systems, in which the system gets to say, okay, what you have done doesn't count as IP, isn't worthy of protection. We get to exploit it and do whatever we want with it, but you don't have the same reciprocal right when it comes to our stuff. Some of this has to do with some of the problems that were discussed in some of the panels yesterday. So, for example, when Professor Reed was talking about, okay, what are the motivations? What are the objectives for creating and engaging in music in his community, right? That music is a way of communing with nature and the universe. That's very different than what we think about in Western music constructs, right? We think about music as a way to express yourself, maybe to communicate with other human beings. But much of what Professor Reed was talking about, communicating with animals, with the universe, with plants, et cetera, is just not a part of that. So we, at the first level, it appears as if we have completely incompatible systems, right? And the first thing that we might try to lean towards is to say that, well, maybe what we ought to be doing is letting each culture's system rule, right? But of course, knowledge, information, creative and information, innovative achievement, it doesn't stay within borders, right? It flows across borders. It flows throughout our global system as a whole. And so it's impractical to say that, okay, well, we'll have a Western system and then we'll have a non-Western system. We will apply our rules. You will apply your rules. That's not going to work, right? The other thought could be to say, well, why don't we just deconstruct the entire prevailing Western model? Right? Many non-Western cultures were not a part of the conversation when the modern IP system was constructed. So perhaps that's a good reason to just take the whole system apart and start all over again and make sure that everybody's at the table. There are practical problems with that, right? There are nations and societies that are entrenched in the prevailing model. And so as a result, it's not likely that many of the prevailing parties, the prevailing systems are going to give up, right? So we're left with, how do we reconcile these things? How do we pull it together? We don't want the prevailing system of exploitation and inequity to continue, but we do need to figure out a way to bring these things together such that everybody is included and everybody has an equitable interest and participation in what we call the overarching IP regime. So one of the things that we try to do in the book chapter that Kamal Patterson referenced at the beginning of his introduction of us is that Professor Jamar and I, we try to tackle this problem. We try to look at what is it that non-Western cultures, marginalized communities, what are they doing in terms of creative and innovative accomplishment that the IP system is not recognizing? Anything from traditional knowledge and expression to other intellectual achievement. And how do we get the level of protection and respect and control that these communities are interested in? And what we've tried to formulate is sort of like a 3-tier approach. The first thing to do is something that has been talked about a lot this morning, and that is that educating these communities, educating these peoples, educating these groups about the Western IP system, not necessarily to absorb them into it, but to empower them to use those systems strategically, right? If you may not be thinking about your achievement as fitting into Western copyright, for example, but if it fits in such a way that you're able to exercise certain rights, right, to make use of your exclusive rights in that system, maybe you're not interested in making money. Maybe you don't want to use it in the traditional property sense. But if you have the right and you can use it to exclude others from making use of your creative achievement, not for commercial reasons, but because you think that the way in which those communities want to use your work is disrespectful, inconsistent with your values, et cetera, et cetera. In our society all the time, we have people who have property rights, and you utilize those property rights to achieve your goals. Just because your goals aren't what other people would use those rights for, just because you aren't interested in making money, doesn't mean that you can't utilize those rights to achieve the ends that are important to you. We see this, for example, with many musicians who object to the way in which their music is used in certain political campaigns, right? Say, I don't want to be affiliated with your, it doesn't matter how much you pay me, all right? I'm not going to license that. So step one, educating communities as to how they can make strategic use of systems that are incompatible with their own value systems is the first step towards exercising some control. Step two, there are circumstances in which what a particular community creates, what they're interested in protecting, doesn't fit completely or easily within the IP system, but there are some circumstances in which minor adaptations to the system can solve the problem, right? And if a minor adaptation is not going to wreak havoc on the system, well, in the interest of mutual compatibility, of bringing two different cultures together in our global IP system, then we think that that's worthwhile. So, for example, one example of that is, and many people have talked about it, broader use of geographic indicators, for example. We use geographic indicators to show that, for example, a particular wine comes from a particular region of a society, or a particular cheese comes from a particular place in France. Well, those things can be used on behalf of various communities, indigenous peoples, groups, that they can use such indicators to say that, okay, well, if you want to make use of this particular type of expression, if we authorize it, if it's coming from us, if we say it's authentic, it will have this mark, right? So we aren't necessarily going to be able to prevent other people from engaging in this activity, but this will at least let the world know that if you don't see this mark, well, then you know these are imitators. This isn't coming from us, right? So that, again, moves us one step closer. Finally, the last step that we've articulated is you will reach some situations in which what the outside group is seeking to protect and how they want to protect it is inconsistent with the prevailing Western IP framework. And that's where the rubber really meets the road. And that's where you have to sit down and figure out how you're going to reconcile these competing notions and competing sets of objectives. There, what we suggest is that the key thing that we have to do is that we have to move away from the faulty premise. And that's the premise that I referenced at the very beginning. At the very outset, what you have is this Western notion that what you're doing isn't IP, and what I'm doing is IP. And we have to challenge that, okay? Because every culture, every society has systems to promote knowledge development, knowledge use, cultural enhancement, all of the things that we're thinking about in terms of our IP system. Just because they may use a different lexicon, or just because they may embrace different values, it doesn't mean that their IP values are inferior to our IP values. What you want to do is you want to take a look at, okay, what are their objectives? If their objectives are the promotion of development of creative expression, the promotion of the development of innovative enterprise, right? To develop the kinds of things that we normally think about as IP, then what we have to do is we have to incorporate their values on an equal level with our traditional values, right? And see how it is that we can reconcile the two, because both systems are trying to accomplish the same thing. Both systems are trying to encourage intellectual endeavor. And at the end result is that we're going to have more of that type of activity, which of course is what the intellectual property system is all about in the first place. So I think I'm going to stop there because I think I'm just about at time, and I will save the rest for when we get into some Q&A. Thanks.
Thank you, Professor Antima. Now we will have Professor Chen.
Thank you. And it's a real honor to follow both Fumi and Professor Matima, Professor Arewa. And I apologize, I'm California time, so it's a little early for me still, but I'm just honored to be on this panel. I would like to actually ask Professor Matima if he could put a link to his article in the chat, because his work has been so fundamental, I think, for many of us. And as I mentioned, I'm a newcomer, I think, to focusing on equity, tenure. And so I'm really catching up and learning a lot from his work and others, and just honored to be on the panel. So I just wanted to start with kind of returning to and centering the voices of the people that we, I think, as IP professionals are studying. And I think there's always this kind of question of, I worked in government before, and it's this admiring the problem. So I think as a tendency as academics, we have and I'm not counting the representative on the panel, who I'm so honored to again to be in the presence of, but we have a tendency to admire the problem. We study the problem, we look around and we think about it. And we tend not to, that creates some distance from the actual people. So a diary project that I recently launched with some companies has been asking this very basic question of what does it mean to be an inventor to you? So I'm going to just play some of these narratives and then talk a little bit about the project that I'm working on in this space, which I think, again, really follows from what Professor Matima just talked about. It's almost like completely maps, but in a different way. And I just, so people that I have not been in this audience before, my name is Colleen Chen. I'm a professor at Santa Clara Law School, and I focus on patent law and I focus on empirics. So I kind of bring those angles to this work, but I also am somebody who I think, is very committed to social justice and has done actually a lot of work in the criminal justice system and working with marginalized groups. And so I feel like that I can bring to the table a little bit, but primarily I am, I come trained as an empiricist. And so the way I talk about things is going to be different, but I think it brings a different level of truth, a different kind of truth that reinforces a lot of what's been said and also hopefully the lived experience, which is the most important. So let me just play these. I'm not going to read them. I'm just going to let you read the answers to this question. What does it mean to be an inventor to you? I want to now turn to, having looked at these, and I think we'll talk about them a little bit, or we'll try to remark on them in my comments. I do want to note a couple of things about these comments. I know we've been talking about copyright. This is really about patenting. But at the end of the day, it's about a lot of what Professor Arewa and Professor Matima talked about, being seen and getting credit and getting economic benefit from creation and creativity. And having that reward, whether it be through the IP system or it be through a financial arrangement, royalties, is what fuels then the additional effort and the intellectual engagement. And what is, I think, interesting about these responses is when I asked this question, I really, this person now is, I think, in his 40s. I was really surprised at what I heard from people. I expected to, some of it I did expect to see, but what I was surprised is how important these folks are. Not independent inventors. They're not working, independently or, sort of on their own project and then getting patents. These are actually people already in a company. These are people with good paying jobs. They're engineers, they're well compensated, but the patent awards can still really mean a lot to them in terms of being seen, in terms of feeling validated, but also economically in terms of the patent awards, because a company benefits from the extraction of those ideas, putting them into property. The company benefits. And so when the company then gives back to those people who it's hired to do that, there can be a direct benefit. And I remember talking to another colleague of ours in the IP world and him saying, I talked to some of my friends who are members of underrepresented groups at companies. And I said, well, aren't you doing patenting as well? And they said, well, we don't even know anything about that. And then when they asked around, they talked to other folks and they said, oh yeah, those other folks are actually using patents to pay for college, to pay for things. And there just was no awareness of it. There was no sense that they could even do that, or that it was even interesting, or it was even valuable. So what I want to do now is turn to something that's more, I hope he won't be embarrassed, or it won't be, will be okay with me doing this. I haven't asked for permission, so I apologize. But I do, okay, so if he's giving the go ahead. So I think that I do want to acknowledge what I think is so special about Professor Matima is that he isn't just Professor Matima, he's also this entrepreneur and this kind of innovator himself, and has come up with the IPSJ, which we're all familiar with. But he's also launched recently with a student of his, a program to actually recognize future IP professionals and think about what they need and meet them where they are. So this is the Tech Law Summit. He presented about it at a conference I organized in the fall called the Diversity Pilots Initiative. I'll talk about that briefly. But he was recently willing to share with me some of the narratives from his students who had benefited from being recognized as future potential inventors. And I just want to present their stories briefly, in brief. He talks here about the recognition, and he also talks about how this is actually going to enable him to do things, right? Just like the person before was enabled to pay a down payment. And the quote goes on and on. It talks about how they were actually able to use that down payment to feel like more part of a community, and to sort of have the ability. They had a third kid coming and they didn't know how they were going to pay for things. And they used their patent royalties to help them actually, continue to stay in the job and be successful. An earlier speaker in that session also talked about, kind of, again, what this can enable, right? The young person getting something, and a reward, and a recognition that allows for many other things. And it sets off this cycle of prosperity, which is all what we want, right? We want the IP system to fuel prosperity. And Alison Horton's, again, her narrative goes on and talks about how without that recognition and the award itself, there would not be the additional ability to even participate. Now, I think what's missing in the diary narratives that I showed earlier is that it's really not a set of diverse voices at all, right? We told about 200 people, 25 responses. I had one Black engineer, and I didn't have any comments from that person about the story. I had mostly Indian, Asian and white people. I had women. And again, even for them, being a senior engineer, it really still mattered to be recognized. And so the question is, how are we making sure that this recognition, all these benefits, all the prosperity, all the emotional and psychic benefits that come even to a senior engineer are being actually accessible to all? And I hope you're not hearing that really loud lawnmower next door. So apologize if you are. Anyway, I want to now switch, allow people to have the conversation. I'll just quickly highlight the Diversity Pilots Initiative. We are working with people like Professor Matima and others to really, I think about this question of attribution, and think about how do we actually, if we want to have a diverse participation, how do we actually accomplish that? And using some of the tools of social science to do that. So this is the Diversity Pilots Initiative. And the goal is, again, to test and improve changes to law, policy, and practice to advance diversity and innovation and invention. And our tool is, we hope to use storytelling, but a lot of it is rigorous evaluation. So partly I'm doing the survey, and what I want to see hopefully over time is the differences in narratives between what women say, what Black inventors say, what white senior inventors say that are older, what junior inventors say about that patenting process. So there's different papers out there. And again, we're open for business. We just launched, and we love to work with different folks. So if you're interested, please hit me up. So we did a conference in the fall, and the sort of organizers of that were Margot Bagley and myself. But we also worked with the patent office. We worked with an econometrician. So we try to really work with everybody that is interested in this topic. I'm not going to talk too much more about this. What I will jump to is what I think we're trying to bring is this basic problem of, even if you actually look at who is in the STEM workforce, and if you went even before that, right? If we looked at, participation in engineering majors, it is higher than who actually gets in the workforce, which is higher than who invents, right? So we have this attrition cycle all the way. And we've known this, if you've looked at the HBCU conversion and employment rates, they're very high for engineering. They're not as high as for, there is a racial gap still in engineering. It's slight, it's not that great. But there is that gap. And then in invention, because again, the statistics we have are very poor, it's not great to know. We don't really know, but we probably think it's not great. So anyway, this conversion rate is for women. That's the data that we have. And I'll just kind of talk through one thing is what we're trying to do is think about opening this black box and getting into, what's actually happening at the point of submission, at the point of application and prosecution. So I want to talk about the point of application. And I apologize again to some people who've seen this already, but I think one question we have as people who are in audiences all the time and also teaching audiences is you also often have a process when the question is asked, should I raise my hand to ask a question or something, that there's a mental process that goes internally. So it just goes exactly back to what Professor Matima talked about, is what I actually have to say interesting, or is what I have to contribute? Is it patent worthy, or is it copyright worthy? Is it worthy of protection? Do I actually have something? Am I somebody who identifies with being an innovator? People told me that I'm an innovator. And we know that the person who raises their hand is all the time in the class, right? All the time, doesn't have all the best ideas. And a lot of the best ideas are out there. And again, I think for those of us who are academics, it's the same thing. We want to get recognition for our work. We are very, at least I'll just talk to myself. I shouldn't generalize. But having talked to a lot of people, I do think there's just a general discomfort with tooting our own horn. And we saw these responses when we talked to potential inventors as well. I think I'm almost out of time. But what I'll say is, again, there are ways to, as we know in the classroom, get away from opting out. I'm not going to go through this into opting into opting out. So if we ask people explicitly, we might get better participation. The last thing I just want to say briefly is that we have done work to look at identity and whether people think that they are inventive enough or innovators. Again, when the world has told you that inventors look like this, it's very different when you call it inventorship versus problem solving. But in these surveys, one thing we have teased out is the difference between women and members of underrepresented groups, which always tend to get lumped together. We're really trying in the data to do a better job of separating them. It's still difficult because the numbers are small. But social networks are extremely important. So that's why I think this work apparently specifically is so important. And the work of the Unleashing American Innovation Act is so critical, as is the Chips and Science regional hubs, actually ensuring and focusing on underrepresented groups in general, trying to think about these social networks. There's just a lack of awareness. There's a lack of awareness that this is actually a huge, potential economic driver. And there's also a lack of a mentor, a lack of, collaboration. So all these social factors are infecting the, IP process as would be expected. And I think we really need to address them. So I'll stop there. Sorry for using extra time.
Thank you so very much, Professor Chen. Next, we have the Honorable Hank Johnson.
Thank you, everyone. It's my honor to be with you all today, such esteemed professionals, and I've learned a lot in listening to you all, and even learned a little bit about myself, Professor Chen. So I'm Hank Johnson. I represent Georgia's 4th Congressional District in the United States Congress. I have served for the last, this is my 9th term. So I'm in my 17th year. And I'll tell you that time has gone by. During that time, there have been many, since 2006, many advancements made technologically. And I think I'm just awakening to how ubiquitous artificial intelligence will become. Actually, it already has become. There's so many functions wherein the private sector is applying artificial intelligence, and a lot of the basis for artificial intelligence is the input of data which computers can then crunch to come up with likely answers. So it's not really real intelligence, it's artificial intelligence. It's not human logic based on values, it's just straight machine calculations. And so when you have questions or information that is going into the database that is used to produce the artificial intelligence result, if that input is the way that our society has always been, and that is lacking in diversity in all areas, from thought processes to creativity, you miss something. But yet, it seems that even though our society is systemic racism is at the root of every enterprise in our country, still diverse voices, underrepresented communities, Black folks, whatever you want to call minorities, Latinos, women, Asians, have always been able to rise up and represent in such a way, but in terms of intellectual property, it has always been exploited. Creators, take music for instance, the makers or the ideas and the performers, the ideas for the performance and the performance itself, and used to be the physical embodiment of that performance, a record or an album. The creators and the performers did not get, ownership. So they were just given pennies on the dollar. So yes, kind of like sharecropping, Professor Arwewa. And so at this point, here we are with technology converging at a time when authoritarianism and attacks on democracy are the norm, even in our country. And what is consistent with this move towards authoritarianism and attacking freedom, democracy, is censorship. And so what we're seeing today in the field of music is censorship. When it comes to rap music, which is Black music, which is Black culture, which is Black freedom, freedom to create, freedom to contribute to the culture. Freedom is under attack in the music industry on the traditional creators. And by the way, while that attack is happening on the creators, the exploiters are going to continue to go to the bank with the profits. So take the case of 21 Savage. Well, I won't take the case of 21 Savage right now. Let me take the case of arising out of Atlanta, Young Thug and Gunna. And I must admit to you right now, I have a confession. Before I went to Congress, before I came to Congress, I was a criminal defense lawyer for 27 years. So I bring that distinction to the table in all honesty. And I'm being a little facetious right there. But at any rate, that's a case where individuals are being prosecuted based on the content of their lyrics. When you go to the indictment, when you read the 88-page indictment, you can find it on the internet. you will see that it accuses a number of people, including two famous rap artists, with participating in a criminal conspiracy, a racketeering enterprise, a RICO case. And it sets forth about 180 acts in furtherance of the conspiracy. And among those acts in furtherance of the conspiracy set forth in the indictment are pictures of rappers throwing up gang signs, they say. Well, what is a gang sign? Or what is the difference between a gang sign and when a group of young people take pictures and you got people doing all kinds of stuff with their hands, and you don't know what that stuff means. And they don't know what the stuff means either. But the fact that that a picture or a video, intellectual property, by the way, who owns that picture? Who owns that video? But the fact that the content of the video shows something that someone is construing as a gang symbol becomes evidence used against them. Go read that indictment. The indictment itself sets out the pictures, the videos, the rap lyrics that constitute a overt act in furtherance of the conspiracy. So in other words, the very act of writing a lyric and publishing a lyric is being used as evidence of criminal activity. This is nothing more than, well, I won't say it's nothing more, but it is an attack on freedom of speech, on creativity, on the ability of a rap artist to engage in something that everyone else can engage in. Anybody else who wants to write a poem, or in let's say in another genre of music, if Johnny Cash says that I shot a man in Reno just to watch him die, or the artist from Queen says that I shot him in his head, now he's dead, something, if they are not charged, but the rap artist is charged, and they are white and the rap artist is Black, well, there's a correlation there that has a historic significance. And why is this happening right now, this attack on the freedom of thought, on creativity that is directed this time at Black people? As I said at the outset, these are some times that we're challenged in terms of the rise of authoritarianism across the country and or across the world, and the attacks on democracy inside of our country, consistent with that world trend. That's one reason. Another reason is ignorance, and another reason is just racism. But so I have introduced the Restoring Artistic Protections Act, also known as the RAP Act. And what it would do would be to put in place, well, it would create a presumption that creative content is unavailable for use as evidence in a criminal proceeding. In other words, there's a presumption that you can't use that kind of content as evidence, unless there are certain showings that are made to the court outside of the presence of the jury that can convince the court by clear and convincing evidence that, yes, that creative expression was meant or intended to be true and bears relations to the criminal charges at hand. So it puts up some guardrails. But I wanted to just simply make the point in this discussion that creative content is under attack in this country. Black folks are the first to feel it based on the attack on rap music. And I also would take the opportunity to say that our culture has always led in terms of money or revenue. Rap music is the most streamed and provides the most revenue. It's the highest grossing monetarily genre in the world at this point. And so somebody's making money off of it while others are being persecuted for laying it down so that others can make the money. And so with that, I'll conclude my remarks.
Thank you very much, Representative Johnson. Now we have our final esteemed panelist, Attorney Caleb Green.
Thank you, Kamal. And I want to thank the organizers and want to recognize my co-panelists. It's an honor to be here. I'm very grateful to be invited and to share the virtual stage with each of you, thought leaders and legal scholars in your own right. And it's been great just sitting here and listening to everything all the work that you all have been doing. And I'm glad to share a little bit of my contribution to copyright policy and intellectual property policy, especially as it pertains to marginalized, unrepresented communities. I'm going to talk a little bit by way of introduction. My name is Caleb Green. I'm an attorney here in Las Vegas, Nevada, where I practice at Dickinson Wright, where I primarily do intellectual property litigation, as well as strategy and prosecution. I have been involved in policy for quite a bit, a member of the ABA. I'm actually here in Louisville now at the National Bar Association mid-year conference, where I actually just did a presentation on cultural responsibility in trademark and branding and the importance there. We talked a little bit about a lot of different, recent probably misuses or oversights of cultural and social responsibility as it pertains to trademark and branding. Examples like the Juneteenth ice cream that Walmart put out. We talked a little bit about the recent trademark opposition for Adidas against the Black Lives Matter trademark. So we did a lot there, but I've kind of shifted my, one of my recent efforts has really been in the copyright area, and it's resulted in a recent bill that's been brought before the Nevada legislature. It recently passed the Senate with unanimous, state Senate with unanimous votes, and is on to the Assembly side. But it deals with the issue of copyright weaponization and protecting the transparency of law enforcement. And you probably heard the term copyright weaponization before. I credit some of it to being, I think it's a term that's been around for a while, but it kind of got illuminated in a law review article by Professor Kathy Smith who's a professor in Montana's law school. And it effectively talks about a lot of ways where copyright is kind of being used to advance non-copyright interests. And it kind of balances, sometimes copyright is used to advance interests that weren't originally intended for copyright to protect. Some cases, I think, I like to tell people that copyright is kind of like the speed limit, right? We all break it all the time. Sometimes a lot of it's legally actionable, but some of it's not really practical. So we don't ever really see those disputes. Someone taking a picture of you that you ask them to take a picture of you and then you post it on Instagram. Who's the owner there? Is there an implied license? Those are things that we may not get answers to because just likely it's not really practical to get litigated against. But I think when we couple that kind of this gray area of what is copyright, how is it enforceable or not, and we look at the recent tools that are being implemented on a lot of video sharing services that really take a more aggressive approach to trying to be proactive. We all know about the DMCA and how internet service providers, have to comply with Section 512 in order to, not be held, liable on behalf of content that their users are posting. And one aspect of copyright weaponization we've seen is police officers actually taking those algorithms and trying to use them against citizens who are making lawful recordings of law enforcement. And they do this by playing copyright protected music while they're being recorded. And it's something we've seen multiple times in California. But I think one of the most concerning ones that I had was actually that I uncovered was in Illinois. I believe it's in Ottawa, Illinois. There was an incident report that was submitted by a police officer, and similar situation. He was being recorded by a citizen. And in the incident report, he noted and recognized that the sheriff's office actually had trained them to, when they are being recorded, to pull out their phones, pull out Spotify, play whatever music that you like. Doesn't have to be Spotify, whichever their music streaming platform of choice. And the effort is really to stop the widespread sharing of these videos. And we really see this uptick really since the murder of George Floyd. And I don't think that's a coincidence, because I think we all were forced to sit at home while we were under stay-at-home orders or social distancing orders. We really had to sit and watch that. And I think the most, although necessarily wasn't, I think one of the most critical elements of that was the video recording that was shared widespread on the internet. And I think in order to combat that, we've seen some police officers pick up those practices. And so I was happy to work with one of our local senators who put a bill together that I wrote the section 2 of the bill, which requires all of our law enforcement departments, and I'll be assisting them in drafting and having a written policy that prohibits that action of playing protected music, copyright protected music, in effort to trigger copyright infringement, specifically with sharing it on internet services. So it is a big issue. I would say copyright weaponization is a lot beyond that, and I'm going to wrap up before so we can move forward to the questions. But there are other questions about when it pertains to copyright advancing non-copyright interests. Where should we draw that line? If we look at, I thought some other interesting points of what people call copyright weaponization is when it's used, especially in the political realm. Another example that's close to home here in Nevada is, Senator Reid, who's the former majority Senate leader. He had an opponent, Sharon Ingalls, who was a Tea Party Republican. And they got into copyright disputes, because each of them were allegedly using clips of each other in their attack ads. And they were clips that they didn't necessarily own, and the other party had copyright ownership. And so the debate about, is that something that we want copyright? And so copyright weaponization it's something that we need to continue to have conversations about and discuss. Are these things that we want copyright to actually be enforced against? What non-copyright interests do we want copyright to actually address, and which ones do we not? And I think having the conversation, I think the weaponization bill is one that we discussed. And when I presented it to the Senate Judiciary Committee, their eyes lit up, because they didn't realize how this could really be weaponized and used against, citizens. And it also, what was, one of the, the attacks against the bill was that, well, we don't have any evidence of this happening in Nevada, right? Why is this a Nevada problem? And I think my retort was, of course, well, I'm glad hopefully it's not a problem in Nevada. And this bill makes sure it's never an issue. But when we actually had opportunity public comment, we had a few people testify and say, this has actually happened, but because it's such a fleeting issue, many of these social media websites have different, some more aggressive with the algorithms and enforcing copyright, and some are less aggressive and allow it to run more rampant. And sometimes you have a site that may talk about or have a 3-strike policy, and maybe you already have 2 strikes. And that may be, that may prohibit you from uploading a particular video to a site because you fear, your account may be banned or your account may be suspended or you may have some other kind of consequences. So it's a fleeting issue that just because it hasn't necessarily been reported doesn't mean it happened, but we actually did get several individuals who reached out, and I think it's really raised a lot of awareness as to this practice. And I think it's something that we need to continue to have conversations on, not just with this specific iteration of copyright weaponization as pertains to police officers, but others, so we can have those conversations and either formulate laws or reform our current copyright laws so that we can address and enforce, or at least choose which non-copyright interests we want to advance and which we don't. So with that, I'll pass it over.
All right. Thank you very much, Attorney Green, and thank you, panelists, for your excellent remarks and presentations. I think now we'd like to move on to the question and answer part of our panel. I think I will start with Professor Arewa, and I'd like to ask if you could provide us with an illustration of African-American artists having to wrestle with an incident concerning ownership of cultural material. How did our copyright system stakeholders respond, and how should they have responded?
Well, I should just preface my remarks by saying I do archival research, so a lot of my examples are historical. I think generally the first thing we need to talk about, and I think the first point I would make is that we often engage in discussions about copyright, and I think I just want to highlight some of the comments that were made about non-copyright uses. And I think it's very widespread. We often, as IP scholars, focus on the IP rights and sort of extract them from the actual context within which those rights are exercised, which includes things like strategic uses. It also includes normative practices within the industry that are, the industry often has a dialogue about copyright, how copyright's essential, but that's really inconsistent with how the recording industry has behaved historically. So I want to go back to the dawn of the recording industry, where we had folklorists that were the first that went out and started to collect African-American music. Right after the end of slavery, there was a songbook of spirituals published, I believe in 1867. It was called Slave Songs of the United States. And it was published actually by abolitionists. And when you read the introduction, and that was really one of the first widespread distributions of African-American music, because if you think about the history of African-American music, a lot of it was contained within African-American communities who were enslaved. With the emancipation of African-American communities, you started to have that music spread with people. Now in the recording era, we saw it spread with records as well. But in the 19th century, really, sheet music was our only way to really distribute music outside of human memory. So the folklorists that went to collect this music, we have no idea what they collected and what was available for them to collect. So we have a slanting of history in that the early folklorists in the 19th century and the later folklorists like Alan Lomax, I think both John and Alan Lomax are sort of the 20th century examples. They made determinations about what was Black music. More importantly, with the later folklorists like Alan Lomax, he actually claimed ownership. So one of the things, if you look at his interactions with Lead Belly, in his archives, when you read his letters, he basically says, I'm going to go out and I heard this song from Lead Belly and I'm going to go out and copyright it right now. And it reflects what I call ecosystems of exploitation, because everyone knew his music publisher, the recording company, they all knew that Lead Belly had rights to this song. And they basically said, you need to settle with Lead Belly. No one said, well, this really should be Lead Belly's song. There was a normative assumption that it was fine for him to claim ownership rights because he was entitled to it. And this goes back to a long dialogue about African-American creativity that actually goes back to Thomas Jefferson, which I talk about in my book. He really thought that African-American people had limited creative potential. And this conception of limited creative capacity underlies a lot of treatment of African-American music and claims of ownership, because if you think people aren't really creative, it justifies societally claiming ownership rights over their creations. And I think that's a fundamental thing if we go back in history, and it continues to today. There's a tendency to want to extract out African-American people from African-American cultural creations. And so, we see it in the era of cover recordings. Pat Boone would record Little Richard songs. We see it today to some extent with hip hop, in that there's and I think that's sort of a racialized conception of ownership, where we've seen patterns of extraction of both physical property and intangible property. And I see that as being a core issue that we need to attend to. And it's not just a copyright issue. It's largely a copyright issue in that we treat copyright registrations as presumptive, a presumptive reflection of ownership. And that, if we look at the history of African-American music and claims of ownership, that clearly is a wrong assumption, because we've had extraction in very varied ways. So one of the first ways you might do that is maybe reassess how we treat the copyright registration. And also we need to address those underlying attitudes about creativity, because I think they shape people's assumptions about who's creative and where the nexus of creativity actually is.
Thank you, Professor Arewa. The next question I have is for Professor Ntima, and it's, how should traditional knowledge and expressions be understood within our current copyright system? Should they be considered public domain works? Can some forms of TKE be analogized to currently accepted forms of authorship and ownership?
Well, thank you. I think that's a great question on so many different levels, because it also gives us an opportunity to look at everything that we've been talking about throughout this conference, and to see how significant this conference has been in terms of pulling together all of these important issues. So first, TKE, it should not be public domain by default, right? Because all that does is that it further entrenches these notions that one culture gets to decide, okay, what is IP and what is protectable, right? So instead, I would fall back to that three-part analysis that I talked about earlier, to look at the material, and then assess it, and ultimately see whether or not the objections to it falling into the public domain are those objections wholly inconsistent with the notion of promoting intellectual endeavor. So if the reason that someone is saying, well, it shouldn't be public domain is because it has something to do with religion, well, that's not an IP issue, right? We look at that through a religious lens, right? And not just the lens of only one culture's religion. But if the reasons have to do with promoting intellectual endeavor, well, then their reasons are just as valuable as our reasons for promoting intellectual endeavor, and the assessment has to be done on that basis. So all in all, what we end up with is a notion that the first thing that we have to do in terms of those questions of TKE, but also questions in connection with marginalized community, Black creator content, improvisational content, jazz, things that we talked about throughout this conference, is that what has been being discussed for the yesterday and today has been, first, let's recalibrate the IP system to be more inclusive, to include more types of creative and innovative accomplishment, because that's what our system is supposed to be all about, right? And nothing should automatically be left out, because if you leave certain things out, then you are actually disincentivizing that type of creative and innovative endeavor. Next, at the same time that you want to make certain that the system is more inclusive, such that things like TKE and marginalized community achievement is not left out, you also have to correct the current inequities within the system as they exist. These are the types of things that folks like Professor Mulrain was talking about earlier, but also on this panel with Congressman Johnson and Attorney Green, the particular mechanisms that they're looking at to make certain that the system works properly today for people in real time. And then finally, I would add that this is one of the reasons why I'm a fan of the work that Professor Chen and others have been doing. And that is, in addition to fixing the inequities within the system, let's acknowledge that there are ways in which we can get the system to work for us. One of the problems that we focus so much on the ways in which the system has been exploitative and unfair, but let's also think about how our communities can make use of these systems, how we can get people into these systems, and how we can get our communities to benefit from these systems, because they aren't going to go away, right? And so we want this system. That's what inclusion in terms of the IP system is all about. It's not just about material and content, right? Which was the basis of your original question, right? TKE, marginalized community, creative and innovative output, but also about getting the creators and the innovators in the system themselves and in a beneficial way as opposed to an exploitative way.
Thank you very much, Professor Antima. The next question I have is for Professor Chen. Attorneys know that inventions and products may be eligible for both patent and copyright protection, but often people in the creative arts do not. Would educating people from marginalized communities working in the creative arts on the basics of IP law be a good investment for the entertainment industry and creative industry stakeholders who could share in the profits?
I think the question of education is really important, because you presume that people have an equal understanding of what it is, not only how to get it, but why to get it. I think the great thing about copyright is that the registration process is relatively straightforward. It's can be complicated, but it's a lot easier than getting a patent. But you still need to understand the why. Why do it? And I think then that's where the peer, or cultural icons saying, I got my copyright. I got, let's start when I was at my beginning. This is what it was able to get me, and this is the leverage I was able to use. So I think education is important, but it has to be education that's appropriate and that is really focused on what's in it for me. Because asking them to believe in the IP system, asking them to believe that the IP system matters, that it's worth it to spend that time rather than spending that time on something else, which is also going to be very important, like getting, sort of hustling, getting the relationships, getting the deals, right? All the things that entrepreneurs are doing and the creators are doing. They're trying to get their name out. They're trying to get that lift. So I can get a lift from different things. Why spend time on IP when I could be, trying to just increase my profile on TikTok and get more people to engage in my music and my work? We need to make sure they understand the value proposition. We need to do better as a system. And part of that is acquisition and then enforcement. What does it do? Just having a piece of paper doesn't mean anything. And having a registration doesn't mean anything. What can you then do with that? What's in it for them? So I think the education needs to be, tailored, and it has to be appropriate. Would it be a good thing because I'm on the patent side, for all, potential inventors to just file a bunch of patents? That isn't necessarily going to be the best thing for them. So I think we need to center the creator's interests. And that's why I think what I appreciate hearing about on this panel really is like, IP is a means to the end, but the end is what we really need to focus on. So less IP might be sometimes the answer. More IP might be sometimes the answer to how to get to the end.
Thank you, Professor Chen. The next question is for Representative Johnson. I'd like to know, how did you and your staff develop the case studies that you relied upon when drafting the RAP Act? And was there one example of prosecution based on a rapper's lyrics that you found particularly egregious? And should states consider drafting bills that complement or even expand the protections in the RAP Act?
Thank you for the question. Yeah, it was not case studies upon which the RAP Act was conceived and drafted. It actually came from the concern about 21 Savage, his arrest in Atlanta the night before the Super Bowl. I think it might have been in 2015, 2017, somewhere around in there. But at any rate, he is from Great Britain, and he had a request into the authorities for a green card. And a few days before his arrest, he was on Jimmy Fallon performing a song. And this was during the Trump administration, so it had to have been around 2017. He performed a song, and the lyrics criticized the immigration process and the attack on at the border, the closing of the borders. And a few days after that, he was arrested. He's also known for his for violence in his lyrics and that kind of thing. So his lawyer, his entertainment lawyer, since this arrest happened in DeKalb County, Georgia, which is an area that I represent, his entertainment lawyer called me for some help. And to make a long story short, we kind of came to the conclusion that he was targeted based on his lyrics. And that's how I first got involved in this. We later found that many studies have been done, papers have been written about the number of rappers who have been convicted. And back then it was like 300. Now it's 500 who've been convicted based on the use of rap lyrics in court against them. And of course, the most high profile example of this is the Young Thug Gunna case, which is ongoing in Georgia at this time. I think it's important that as we move forward as a society, in addition to passing the RAP Act, which will protect against the use of creative content against any creator, regardless of genre or medium, that we do a better job of helping our young people understand. And yes, it has to be done through education. And I would recommend K through 12 as a great place to start educating our youth about the usefulness of arts and science, and how the United States Constitution in Article 1, Section 8, subsection 8, provides for securing, to authors and inventors the exclusive right to exploit their creativity, their products, and their creations, and be able to monetize it for a period of time. And so promoting the arts and the sciences is important to enabling marginalized people and communities to come up from the marginalization and to actually monetize and then be able to become even more valuable contributors to our culture, to our economy, and to our society. And with respect to AI, which a lot of products are going to be created based on artificial intelligence, there's going to be even copyrights obtained based on AI. And those products will have protection. But if it's only one, if all segments of our society are not represented in the inputting process, which is ongoing and which provides more accuracy for the artificial intelligence result, if we don't get on top of that right now, we're in trouble. So we should be resisting all legal efforts to shut down diversity, equity, and inclusion initiatives, which are there to kind of level the playing field for marginalized communities.
Thank you very much, Representative Johnson. And I have the next question for Attorney Green. What features of the Nevada anti-copyright weaponization bill should be modeled by other states? And do you think institutional stakeholders and organizational stakeholders such as ABA, the Copyright Society, and others should convene working groups to address this very complex issue of copyright weaponization?
Thanks for the question. It's a really good question. And it's something we kind of wrestled with and trying to get the language. I think, other states, I think it's a good model. And I think, really a lot of it is really more so, explaining the issue of what it is. At its core, really the bill is requiring that there's a written policy that all law enforcement agencies, they have to have, that is enforceable by our Attorney General's office, that prohibits this kind of practice. I think that's a great baseline. Some other states may want to take more aggressive steps, especially states where we see more of it, like California, where they may just want to make it more actionable itself. Maybe there's a private right of action rather than just relying on the Attorney General to be able to enforce. But I think it is a great first step. I think every law enforcement agency, federal and state, should have a policy where that's not going to be used in that way. So I would say that initial language is certainly something that we want to put in there and have other states use. To your point about other stakeholders, I do think it's something that we should focus on. Again, it's kind of as I mentioned, it's kind of a fleeting issue. There's only been a few incidents of it being reported. And one of them, which I found the most egregious, the Ottawa one, was honestly happened by accident. Really, the incident report that the police officer became a public document. And that is the only way that we actually ever found out about it. The person who even recorded it didn't even report it. It was really through, coincidence, through public record search, that someone even came upon it. So I think it is something that we need to look at, whether that's in the form of task force. I think it's definitely something that we need to have conversations about. Again, when I addressed it to the Senate Judiciary, it was kind of like I always say it's kind of like an evil genius type idea. Whoever came up with it was, it's clever, but it's kind of clever for the wrong reasons. I think, and I would say this on a broader point, I think one thing also to consider, this goes into the fair use conversations. We may consider, tacking on, because, again, this is a fleeting issue, may not be something that necessarily gets litigated, but to help some of the service providers and video sharing services, right? They're really the arbitrators of these kind of reports. It's not like this is going to go before a judge, and even judges disagree on whether something's fair use or not. I think we need to expand and have more conversations about the extent of fair use, and the extent, does it extend to works like these or not? Even consider adding additional fair use factors, one that looks into the actual purposes of the Copyright Act. Does it advance the copyright interests that are enumerated and discussed as the purpose of the Copyright Act? So I think those are other discussions that I think the stakeholders should have conversations about. But I would also echo, we do want to look at more narrow issues, such as, this copyright misuse and weaponization being used by law enforcement. That's certainly one aspect that I think can be addressed by looking at weaponization as a whole.
Thank you, Attorney Green. And for our final question, and this is to all the panelists, whoever is interested in answering, please do so. What is one prescription that you'd like to see implemented in our current copyright system that could mitigate the marginalization of vulnerable communities and provide them with greater access to prosperity through our IP system?
I'll start with something more incremental, but to me, which I think is important. I think efforts like what Congressman Johnson are leading and others on this panel are really critical. And so there's been a lot of discussion about the copyright small claims court, which is a really big innovation. And I think what we need to do is actually see if these things are actually, the work is landing. The CI2 of the USPTO is a big effort, and a lot of resources are going into this, but is the work actually getting to the audiences we want them to? Or is it what I call the Chinese granny problem, right? I take my kids to sort of do service work, and we are trying to distribute food to a neighborhood that's primarily Latino. But the people who actually show up to get the food are Chinese grannies with cell phones. They somehow figured out how to get exactly what they need, and they actually may not be the ones who need it the most, right? So I think there's always often a gap between what we intend with policymaking, and again, there's a lot of powerful people on this panel who can really move the needle and do things, but is the work actually landing? So I believe there should be accountability around, and just acknowledgement that we probably won't get it right the first time, and why isn't it working, and what do we need to do next to actually make it work? So that's my one intervention.
I'd like to chime in on that, and to add in, I would love to see more affirmative community outreach and education by the Copyright Office. I think the USPTO has been doing a really great job on that since for many years in terms of providing education and outreach. I think the Copyright Office can do a much better job in that regard. Folks find challenges in navigating the registration system. It should be very, very easy. It oftentimes is not, okay? Folks should have a better understanding of things such as termination rights, what Professor Mulrain was talking about. There's no reason why the Copyright Office should not be doing PSAs on that, right? Because the copyright system is there for everyone, and it doesn't matter that there may be some institutional entities that would prefer that people didn't know about termination rights. The Copyright Office is supposed to be there for both individual rights owners as well as corporate rights owners. So I would like to see, and I know there are many people over at the Copyright Office who believe in this, I would like to see a greater institutional effort on the part of the Copyright Office to get out there into the community and make certain that people have ready access to the information and knowledge that they need in order to take advantage of copyright law.
Yeah, I would recommend that the patent and copyright bars continue and even increase their efforts in terms of providing pro bono services to underserved and marginalized communities.
Thank you. We actually have a couple of questions from the audience that I'd like to present before we go. How do you reconcile the interests of women who are called out by name in rap lyrics, where violence is threatened against them, specifically with the interests of the artist who has written or sung the lyric?
Yeah, I think that there are traditional guidelines of free speech that should be applied, should never be deviated from when it comes to creative content. However abhorrent it might be conceived or perceived, there's still a right to put forward that kind of conduct, that type of content. It appeals to some, while it to others it grates the ear. But that is what art does. Art is gets out of the box and causes you to think. And even you can learn and be motivated for positive activity by negative content. So, it's how you perceive it and how you use it and how you react to it. I think that's most important. So long as it's not threatening violence or, the tradition, slandering or defaming, then it's fair game, it's fair use.
Thank you, Representative Johnson. And I'd like to ask the final question we have in the chat, which is partly a comment. I would love the panelists' perspective on the racial trauma that may exist with the continuing usage of the term brand, given the historical context of branding on slaves. As added context as we look at the usage of language to discuss ownership, how do we keep or hold space for the trauma of the past?
I would just briefly say that it's an ongoing reckoning. I think this was discussed in a prior panel. How we use language has been deeply, in the United States, has been deeply influenced by the fact that slavery was a fundamental part of the United States for so long. Even if we look at the language in the recording industry, we talk about master and slave recordings. I think we have to note where that language comes from. And that's part of an ongoing racial reckoning that we have to really pay attention to. And so notably, I noticed people no longer use the term master bedroom anymore. Now they now say primary bedroom. And that I think is an important change. And in the computer programming arena, people don't talk about master and slave programs anymore. So I think it's important to scrutinize where language comes from and how it's been influenced by conditions of the past and conditions of inequality. So I think this is, as is the case with other uses of language, this is something that's reflective of past traumas that we have to acknowledge today. We don't have to live in that. We have to acknowledge that this today is no longer the past. And one way we break from the past is by changing the language that we use to describe things that embed assumptions and practices of the past.
Thank you, Professor Arewa. And with that comment, we will close our question and answer and close this particular section. I want to thank all of the panelists for their brilliant insights, contributions, scholarship, and experiences.
Thank you.
Thank you for having me.
Thank you.
Thank you. Thank you, Kamal, for your wonderful questions and your guiding us.
Yes, thanks very much. Wonderful moderator.
I second that.
Thank you very much. I appreciate it. It's a privilege and a delight.
So thank you very, very much to this final panel and to all of the panels. When we started this discussion yesterday, we started by using the example of Japanese woodblock printing to illustrate how the way a community of artisans work together can set expectations and practices for how work will be created and credited and who will exercise creative control over aspects of its production and be responsible for its distribution. And I noted that these sorts of practices can serve as an analog for IP protections where none exist, and also that they can work to affect the development of society and of culture itself. And recognizing this, when planning the conference, we wondered what conditions are needed for culture and for innovation to take root and to flourish. And more fundamentally, whose culture, whose innovation, what is culture and what is innovation? And we hoped for a discussion in which we'd also think about the conditions that are best suited for communication and for receiving knowledge and how those circumstances vary. Speaker to speaker, listener to listener, culture to culture, as I said in my opening remarks, and how could we understand each other better? And among other things, I also personally told you that I hoped we would forge bonds of friendship through sharing our academic scholarship with each other. And I think that with the insightful questions and participation of the panels and the moderators, and the thoughtful questions by the audience, we have succeeded and we've exceeded our hopes and our expectations on all scores. And I thank you all for that, all of the panelists, all of the moderators, all of the participants from wherever you are joining our conversation. And I will say for my part, we would love to continue this conversation. I would invite you to keep in touch with us at SIP Squared and to please share your scholarship with us, attend our fall conference, let us know how and when we can participate in and support relevant conversations that you all are having. And I also invite you as a clinical professor to send clients our way to our sponsored clinics. I run an arts and entertainment advocacy clinic. My colleague, who I'll turn it over to in a moment, Professor Sean O'Connor, runs an innovation clinic at the law school. And so we can be boots on the ground as well in serving some of the needs of marginalized creators and innovators as well. So I'll end there and I'll turn to my colleague, Professor Sean O'Connor, for some final words from them to conclude.
Great. Thanks so much, Sandra. Thanks, everyone. This has just been a phenomenal 2 days of programming. Again, I'm Sean O'Connor. I'm the faculty director of SIP Squared. And before I get into some particular thanks, I want to say that this event is in many ways a culmination of something we've been building well, now I have to be careful. Let me just say the remarketing. I would have used a different word before today, the remarketing, repositioning of this center to be very inclusive and to be a situation where we can have hard conversations about difficult things, but do it in a very civil manner. Now, sometimes you can't be civil. Sometimes you have to really take the gloves off. But these 2 days have been phenomenal for this. I would also say that, we want to thank all of our donors. Look at the donors that we have. Know that a lot of these donors, we had the conversations with them as well, that some things that would come up in these 2 days may or may not resonate well with them. But that is part of what we have to do as an independent academic center that is looking to pursue fairness, justice. Let's look at things, look at the systems we've developed to determine how they can better serve all individuals. Now, let me turn to some particular thanks. Sandra A-Stars, Professor A-Stars has really just been the leading light on leading the charge on this conference and has just done a phenomenal job. Now, she also had, as I mentioned yesterday, Joshua Kresh, our managing director, who will be taking on even more of a leadership role soon, really was a lot of the impetus behind the concept for this. And so I really want to give him a particular call out here to Joshua Kresh. Of course, our staff, Christina Pietro, who you all know, and who just keeps everything running here for years and years. She's been with the center for so long. Mary Claire Durrell, who came and joined us a few years ago, and I think just as we were getting into the pandemic, Joshua came in the pandemic as well. And both Christina and Mary Claire really just keep everything running phenomenally well. So we have a great team. But then what was really critical in this conference, putting it together, was to have a steering committee, because we knew that and if you look at myself, Sandra, we know we're not always perhaps the right people to lead a dialogue like this. And so we asked around and we said, who can we have that can guide us so that we make sure that it will not be perfect. And I apologize if anything was not as good or as sensitive or appropriate as it could have been, but we did our level best to bring in people who could then help us. So that steering committee was just so instrumental to make this happen and to expand the range of dialogue. So with all that, with the steering committee, Sandra's leadership, Joshua's leadership, the just untiring efforts of Mary Claire and Christina, and then honestly, again, the support of the donors who allow us to do things financially that are really hard to do. And we've taken them along on this journey to say we need to then be able to have dialogues, and they all get it. All the ones we have, they understand that these need to be the conversations. So with that, let me close out the event. Thank you again to everyone. Look for more things to be happening. Give us suggestions, keep in touch with us. And again, thank you. Have a great day and have a pleasant weekend.